appeal in the matter of the claim on the application of Ozmen and the security of the stay of Ireland.
Just give me 2 seconds, Miss Dakin, if you would.
Indeed, my lord.
Can I ask you a great favour? Could you just move a little bit towards the middle of the court? Maybe even a bit more than that. That's lovely. Move your papers. And I can see you. And so can everybody else. Now, I hope everybody understood the timetable that we've got to finish this case by 12:30 today.
Oh, I wasn't aware of that, my lord, but I don't think there'll be a difficulty.
I don't imagine there will be. Good.
My lord, I appear on behalf of the appellant in this matter, and my learned friend, Mr. Irwin, appears on behalf of the respondent.
Yes.
This is an appeal against the order of Upper Tribunal Judge Norton Taylor, dated the 19th of December 2022, dismissing the appellant's application for judicial review. The application for judicial review sought to challenge 2 decisions of the Respondent Secretary of State. The first dated the 15th of March 2021, and the second, which was an administrative review decision, reviewing the 15th March decision, which was dated the 7th of February 2022. Those decisions arose out of an application made by the appellant for leave to remain in the United Kingdom in order to set up in business. He proposed to establish a business as a mobile barber. The application was made pursuant to the immigration rules preserved by the association agreement between the European Union and Turkey. It's an unusual area of immigration law in the UK, in that the immigration rules, as they were in 1973, continued to be relevant by operation of a standstill clause within the association agreement. It is uncontroversial in these proceedings that the applicable rules are contained within HC 510, explicitly paragraph 21, and the respondent's guidance dated the 30th of March 2020. That is simply by way of introduction to where we are at today. The appellant pursues 3 grounds of appeal. The first is a procedural fairness matter. The appellant contends that the judge was in error to conclude that the respondent was not refusing the application on the basis of questioning the appellant's bona fides, but rather on the basis of the viability of his business proposal. Secondly, that the judge irrationally concluded that the respondent had taken other evidence of the appellant's qualifications and training into account. And thirdly, although it's referred to as ground 4 in the paperwork because ground 3 fell away, the judge was in error to reject the appellant's submissions as to the rationality and fairness of the decisions which focused on travel to one proposed customer. I seek to deal with these grounds in the order in which they are pleaded, and no doubt much of the time will be spent on ground 1 and the issue of procedural fairness.
Well, you call it procedural fairness, but I'm calling it the credibility ground.
Well, yes.
Is that right?
Yes, it is the credibility ground. But in terms of a matter of law, the focus is on the issues in Carrigal and whether, as a matter of fairness, those terms used in the decision amount to an allegation of some sort of bad faith that would give rise to a minded to refuse process or an interview as per Carrigal.
I mean, the problem with that, and I put this to you at the outset so you can deal with it, is that the review decision says exactly the reverse. It says we're not challenging your credibility, we're challenging whether the business is viable.
It says that, but then when one looks at the content of both the decision and the administrative review decision, the context of what is said in the analysis of this application reveals something rather different in my submission. Although the initial decision doesn't use the words credibility, it does use the words claimed employment, and that employment...
So which words?
Claimed.
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 Yeah. Claimed employment. Yeah.
Claimed. Perhaps if I could refer your lordship to the decision itself, it's page 291 of
Yes.
Funding.
The administrative review expressly accepted the claimed employment.
Well,
Page 307, I think.
the bottom paragraph, although it seems to accept that the SGK document would not be able to be provided to confirm the work history, what the administrative review decision goes on to say is that you would have been able to provide further evidence. And that's exactly what the appellant did in this case. He provided 2 certificates of qualifications in addition to the 2 references from his employers. And that's a matter that falls within the other ground that was not taken into account, we say, on the face of the initial decision or the administrative review decision.
So getting back to the initial decision, what words in the initial decision do you say indicate that the genuineness of the appellant's application was in question?
That the work history is claimed work history.
So where precisely is that?
Line 5.
So, yes,
5, yeah.
Last line of the first paragraph. Of the,
under the heading
decision.
insufficient evidence.
Yeah.
So on the basis of no SGK document having been provided, any work history claimed, so the work history doesn't appear to be accepted because it's claimed work history, cannot be verified. And then the word verified is an important word in the context of this decision.
anything else in the initial decision to suggest?
Well, the initial decision is so brief, and it is all that is said on this matter. The decision really doesn't go any further to say, and because of that, your decision, your application, your business proposal is not viable. There's no question mark over the adequacy of the work history itself. It's focused on, you have told us this is what you've done for work, you have given us this evidence, but effectively we don't accept that, we don't believe your work history because we can't verify it.
Well, the last sentence of the initial decision says that he's not satisfied, he or she is not satisfied, documents provided reflect a business proposal with a realistic chance of success. And that is viability, isn't it?
It is, but it doesn't link up with what was said about the work history itself. It's a sentence that stands on its own, but when one looks at the reasons for refusal, and there being effectively two, the work history and the travel issue, then what is said about the work history is that we don't accept what you have put forward because it can't be verified. Now, it may have been different if the applicant had said, I have worked as a barber, and provided no evidence whatsoever. The respondent may have been entitled in those circumstances to conclude that the application doesn't meet the terms of the guidance.
Can we assume you're right for a minute? And the original decision is questioning his the veracity that you produced evidence of work experience, which can't be verified, so we've ignored it, and therefore they are questioning the truthfulness of what he said, that he was an established barber.
Yes.
But you then go to the review decision, and let's assume against you on this analysis that the review decision does make clear that the evidence is accepted that he had worked as a barber, but the what is said is that the business is not viable. Now, do you win in that situation on the basis that the first decision questioned his veracity and nothing was done to check?
Well, then the point would fall away, surely, if on review, and of course it is a review of the initial decision,
yes.
if the reviewer then accepts
yes.
that an individual has the work history as claimed, then there are no other reasons advanced as to why that particular point would make the business not viable.
Well, I'm not sure that follows, does it? I mean, my understanding of the review is that it says it really looks a bit of a difficult business, travelling barber on the bus and in this area as a whole, so that it's doing what Mr. Justice Saini thought was really open to the Secretary of State, which is to evaluate all the facts and circumstances, which is something the court doesn't do. Why is that wrong?
Well, I wasn't addressing the travel issue, sorry, my lord. I thought
I mean, I think that the problem with this case is it's been looked at in little micro-analysis, little pockets of micro-analysis, whereas we don't read these decisions as a deed. We're not chancery. Well, some of us are chancery lawyers, but even those of us who are chancery lawyers don't think it's the right way to approach these decisions, to construe them as a deed. We need to look at them fairly as a whole. And what I would put to you is, read fairly as a whole, what is questioned is that this is a small but non-viable business plan to go around cutting people's hair on the bus, which is in an area where you'd have to go a long distance to do that, and they didn't think the business would get off the ground. Simple as that, not viable.
Well, that's perhaps then when we turn to ground 3, because of course the appellant raises issues with the analysis of the travel decisions and the analysis of the judge. In the first place, the appellant contends that there were simply factual errors in the decision, and you will have seen in the pleadings the issue about the distance travelled was not accurate for all times, and in any event, this was not a distance.
Can you help me with some facts?
Yes.
How did he come to the UK in 2019? Was it a student?
Student visa, is my understanding, yes.
So he's not allowed to work? Or is he allowed to work with a student visa?
No. No.
So he came as a student, did what, a degree, a 3-year degree?
I think it was a short-term student. I'm not sure of the subject,
Short-term.
but a short-term study.
A year. And then what?
And then made this application.
He made it in 2020.
2020, yes, I think in May of 2020. So there was a significant period whilst it was.
So he'd basically done a year's barbering, then he came and did a year's student. Did he study hairdressing, or did he study some other subject?
I may just turn my back. So studied barbering in Turkey and an English language course in the UK.
He did English language.
Yeah.
I see. Okay. That's very helpful. Thank you.
Can I ask one question before we go on? In this court, do you have a rationality challenge based on relying on the absence of the SGK? I think the answer is no, but if the answer is yes, you may not want to deal with it now, but I think it's a point that you need to deal with at some stage.
I mean, certainly the admin review decisions rose back on the absence of the SGK by accepting that it wasn't there, but it probably wouldn't have made any difference because of the nature of the appellant's work in Turkey wouldn't have been reflected in that document, and the administrative reviewer seems to accept that position.
So I think you're accepting that your only rationality challenge, to use that phrase, is in relation to travel loss of
Correct.
bus timetables.
Yes.
Okay, thank you.
We're going to come to ground 3 in a minute.
I am.
I know I'm focusing on ground 1, which is where you thought you'd be spending a lot of time. You've told us what the line you rely on in the initial decision. Is there anything else? Is there anything in the administrative review decision which you rely on to support your case that the issue here was genuineness rather than viability? If I can use those words.
I can refer your Lordship to the bottom of page 307. I should perhaps just make a general observation that although the administrative review decision is quite lengthy, much of it is simply setting out what the applicant's grounds were.
It is, that's
yes.
right.
So the bottom of 307, the last 2 paragraphs, are part of the actual reasoning of the administrative reviewer.
I think the word credibility is used 3 times in the administrative review decision.
Yes.
The first is at the bottom of, towards the bottom of 305, in which the author says in terms, the caseworker would not be under any obligation to make further inquiries to allow you to demonstrate your credibility.
Yes.
Because your application was essentially refused for viability reasons.
Yes.
So the word credibility there is being used in the context of genuineness
Yes.
or honesty. It wasn't, and saying in terms, the Secretary of State's decision was not
saying that.
Not based on any suggestion of dishonesty.
Yes.
So that's the context in which the word credibility is then used at the bottom, twice at the bottom of 307, in the penultimate paragraph,
yes.
and again in the last paragraph.
Indeed. And so the administrative reviewer is then referring to credibility in a context where the respondent is saying, well, this was viability, not genuineness. And so appears to use the term credibility interchangeably. It's not consistent throughout the administrative review decision.
Well, it's not. It's used in both senses in the
is.
guidance, as it can be. No.
Yes, and that's. I don't criticise the judge for observing that in the judgment. I mean, indeed, the judge begins at paragraph 20 by acknowledging that credibility could be used in both contexts. It could support both the appellant and the respondent's argument. I also don't criticise the judge at 21, noting that credibility of the application is used in the guidance in the context of genuineness. That is indeed correct. And at 22, and that's really the crux of this matter, it's the particular circumstances of the case that effectively will reveal how credibility has been used. And that is the space between us in this particular matter. And we say that the context of the words used in the initial decision and what is said in the AR decision, and the absence of any other reasoning on the experience point about the adequacy of experience, simply the fact of it not being made out, not proved, plainly puts the bona fides into contention.
Looking at the way the word credibility is used in the last 2 paragraphs, it's really the last paragraph on 307 which is important, isn't it?
It is.
Because that's the decision. And there, the author talks about credibility of your business.
Yes.
And that is isn't that a viability?
Not when the whole sentence is taken together. You may not have been able to provide the evidence that the initial decision maker seemed to deem was necessary. You would have been able to provide further evidence to demonstrate the credibility of your business other than the 2 reference letters. The reference letters went to the individual's claimed work history.
I mean, I, for what it's worth, and speaking only for myself, I accept it's incredibly badly drafted, right? But some of these things are. But it could, fairly read, mean you needed to supply other evidence to show the business was viable. So you've shown you're a barber, but you know you can't just be a barber sitting in your house and have a business. And the business can only be credible or viable if you show some information as to how you're going to make money out of being a barber. And he hasn't done that to their satisfaction. I mean, you can't just set up with a pair of scissors and sit in your front room and hope somebody will come along and ask you to cut their hair. You have to do something more. And what I'm reading into that personally is that they're asking for more evidence of how you were going to make a viable business. Isn't that a reasonable reading? You're saying you've shown us you're a barber,
Yes.
but that's not good enough.
It's reading an awful lot more into the decision than is there on the face of it.
Well, except that they've already explained that they're talking by credibility about viability.
And yet it's reviewing that initial decision about work history.
You see, I mean, just to make my point so you can answer it, at the bottom of page 305, the original caseworker would not be under any obligation to make further inquiries to allow you to demonstrate your credibility because I mean, again, it's not brilliant, but because your application was essentially refused for viability reasons, not on the basis of genuine intentions. And we're satisfied it was correctly considered under the guidance. And then later they say you could have provided more evidence about that, namely the viability issue, and you didn't. I mean, is that not a fair reading?
I'm unable to accept that that's a fair
You
reading.
say not.
No.
Yeah. And you say, so just put it to me in its most, if you can, in its most attractive way.
The initial decision maker did not accept that he had the requisite experience on the basis of the evidence put forward. The only evidence referred to being the 2 reference letters.
Yes.
On review, part of what was advanced was that the SGK material was not requested, there was no such minded to refuse process, and in any event, there was further evidence of experience or qualifications through the 2 certificates. Now, although there is reference to the certificates in the administrative review decision, it is only when reciting what the appellant's administrative review grounds were. The bottom of page 307, when the administrative reviewer again repeats that an SGK document was not provided to verify the work history claimed. They also note that such a document helps a caseworker assess the credibility of an application and upholds the initial decision as correct for highlighting that. Just one point that I'd like to just highlight at this stage is that the SGK document is not something that is mentioned anywhere in the guidance. So it's a very specific document that an applicant wouldn't necessarily know was expected to verify his employment unless he was asked by the...
Is it the Turkish equivalent of a P45 or something like that?
It's more like a national insurance record, is my understanding.
But it's an official Turkish document?
Yes, yes. but it only records salaried employment.
Yes.
So it's a record of taxes paid.
And here it's a complete red herring.
Well, yes, the administrative reviewer then seems to concede that in light of the specifics of this applicant's work history, that wouldn't have showed on the SGK document, but then goes on to say you could have provided further evidence, but then fails to deal with the two certificates showing qualifications and experience in this field. And that is a matter...
You say the failure to deal, to expressly accept that there was sufficient evidence of qualifications is the fault?
That is part of the fault.
Part of the fault.
The key point in ground one and the fairness and credibility challenge is that in those circumstances where an applicant has put forward references from employers with contact details and evidence of qualifications, without being asked what else could he reasonably have been expected to provide, that is where the question mark over his bona fides brings in that obligation on behalf of the respondent. As I tried to explain earlier, I think context is vital, because you could have had an applicant who just said, I was a barber, and provided no supporting evidence whatsoever. The respondent would be entitled to reject the application and say, well, this isn't viable. You've not provided any evidence that you have this.
But I mean, you're not really addressing my worry, which is the viability worry. I mean, I'm trying to be fair to both sides here, and I'm trying to read this fairly. And you know, there's a lot of, they have to do a lot of these, and they don't have endless time. And reading it fairly, it seems to be saying to me, not that you're not a barber, but that you haven't produced a viable business model. Now, that's a different thing. And you say, and I get it, they should have said, we expressly accept you are a barber. But then, what more did they need to say you haven't produced enough evidence of the viable business model? Should they have said that expressly?
Well, my lord, I don't see any reasons other than the travel point as to why this isn't viable. So if it was not viable because he hadn't demonstrated his capability to do this job.
Well, I'm thinking of, I mean, you know, if I were producing a business plan to become a barber and travel around, I would, for example, show the business need. So I'd say, I've spoken to 23 neighbours, of whom 6 said they would love to have a travelling barber, and there isn't one in this area.
My lord, I mean, that's exactly what the appellant did do in this case. I mean, his business plan, we're focusing on the reasons for refusal, but the business plan went much further than a simple, I want to be a barber and here's my certificates. There was an analysis of competitors within the business plan. He's put forward 4 interested potential customers. One of those is what the respondent picked out as being someone who lives at a distance.
But the reason you're not challenging all that and saying that that was dealt with unfairly or irrationally is because, of course, that is a matter for the Secretary of State to evaluate.
Well,
you haven't said that it was irrational to say that the business plan was not viable.
Restricted to the analysis of the travel issue, that is exactly what grounds.
But as my lord asked you, it's restricted to the travel issue.
Yes, but that's the only reason. There were only 2 reasons for refusal. So one can only assume that the respondent had no issue with the rest of the business plan. I can take you to the business plan, and it's within the papers, but it's much more extensive and does explain how this business is proposed to work with analysis.
Just help me then. Let's assume that they'd said nothing about the travel, but they had just said, we've looked at the business plan and we don't think this is a viable business, right? And we're not going to go into detail, but we don't think it's a viable business. And you would have to accept that that is a point of view. It's not irrational, but it's a point of view you vehemently disagree with. Can you succeed on a rationality challenge or a reasons challenge? Can you succeed on a reasons challenge? Because they just say that what we've looked at it all in great detail and come to the conclusion it's not viable and that's not good enough.
In my submission, that would be a successful challenge.
That would be successful.
Yes. This is a fairly complex.
So that's ground 4. Because if you knock out Glossop, you say there's nothing.
There's nothing.
Okay.
Well, apart from absence of bus timetables.
Well,
the sentence does, in the original one, says you haven't provided bus timetables, ticket costs, and so on and so forth. So it's not just Glossop.
Well, it's Glossop to Marple. I think he's
Sorry,
based in Glossop,
Marple.
so it's the Marple.
Yeah.
It's the Marple one. It does refer to bus timetables, but then we would be, I think, falling into the analysis under paragraph 21 and what the guidance requires, and really going back to the core of these applications. And in 1973, the requirements were so broad, and if an applicant has put forward a plan where he's set aside money in his budget for travel, he said how he's going to travel, he's based in the same town as many of his potential customers, he's given an analysis of any competitors, that would be, on the face of it, sufficient to meet the requirements of paragraph 21.
When you get to ground 3, can you identify for us anything in the guidance or in the authorities which says effectively you don't need to go as far as bus timetables?
The case of Akinci and ECAA are probably useful for this understanding.
I'm sorry, I keep taking you out of order, for which I apologise. But these grounds are all interlinked. Really.
They are. My Lord, if I can ask you to turn up the authorities bundle, I'll take you to Akinci to begin with.
Akinci.
Akinci, yes.
Page 42.
Page 42.
I mean, none of these authorities are binding on us, obviously.
No, it's...
No, but they will be...
They're a useful analysis from the upper tribunal of how the, particularly paragraph 21, operated. Mm-hmm. And the head note is probably all I need to refer to at this stage.
Yeah.
But particularly subparagraph 5 of the head note, which deals with the approach to a business plan.
Yeah.
It's a common sense observation, really, that a plan is a plan. It's not a straitjacket. There has to be the ability to make changes as things get underway. Now, bearing in mind this was an application made when we were in the thick of the pandemic, and the issue taken on the travel situation, for example, was heavily impacted by the pandemic, which the appellant attempted to deal with in his administrative review grounds, to demonstrate that the respondent had made this search, unknown, of course, to the appellant. It wasn't something that he could address as part of his application. He wasn't aware that the respondent was going to conduct their own research and then reach conclusions on it. And then the respondent refused in the administrative review decision to take into account any explanation or clarification on that point, on the basis that it was new material. And what the appellant was seeking to do was correct the respondent's misapprehension on the travel issue and to point to the true factual position and refer to the circumstances of the pandemic. But ultimately, this point of refusal focused on one potential customer. That issue does not then derail the viability of the rest of the business plan. There were 3 other potential customers that had provided letters confirming their interest in this business.
Can you just show us precisely what was said about this customer again? Which page is that?
The initial refusal at page 291. And it's the penultimate paragraph.
Well, that's, as my lord says, you don't read little bits in isolation. One has to read the totality. It's not a very big paragraph. The last 2 sentences of the paragraph are following on the first sentence, in which it's pointed out your client hadn't provided information about public transport. And it's in that context that the decision maker has made his or her own investigation and come up with the information in the last sentence. I mean, isn't the real point here that you hadn't provided the information, not that, not the sort of cross-check of the Marple timetable.
Then I think we go back to what was required by these rules, at the level of detail that was required. The appellant had explained where he lives, the surrounding towns, how he proposed to, and the amount of money that had been set aside to do that in his budget. In my submission, that would be sufficient to meet the terms of paragraph 21.
Well,
we set aside between 120 and 170 pounds a month.
Yes.
Which, on about 22 working days a month, is about £5.50 to about £7 a day. That's all that's in the business plan, isn't it? I think I've got my figures right.
Yes, I think that's correct.
I'm sure I've got that out of the business plan, 120 to 170. But foolishly, I have not written down the page number.
Yes, there was an annual travel expenses projection at page 219 of £1,700.
Yeah, in the table there.
In the total, yes.
It's broken down somewhere?
There's a start-up summary on the previous page. So from 217 to 218, there's a travel expenses of £120 in the start-up summary.
Sorry, where's that? I just can't see that.
Sorry, it's in the table of the top of 218.
There it is, 120. Okay.
And as part of the start-up funding, there was a budget of £2,800 with £1,400 on initial expenses and £800 budgeted for the initial month's salary, with a £167 last-minute expenses.
So going back to the initial decision, the complaint made is that you didn't provide evidence. Sorry, I lost it. You didn't provide evidence of the costings, of how much it would cost. You said how much you would set aside, but not how much it would cost, or timetables.
Yes.
To establish that effective travel can be made within Glossop and the surrounding settlements.
Yes.
That's right, is it? You hadn't provided. Your client hadn't provided that.
That's correct.
So, yeah.
That's correct. But again, going back to what is required by paragraph 21, if that had been the only reason, arguably in a context where there are no particular documents required, where a plan is a projection of how things are anticipated, there needs to be space for movement and changes to be made. In the context of a business plan that has obviously thought about how travel is going to be made and has come up with figures and budget for travel to be completed, and in a context where 3 of the proposed customers live in the same locality to the applicant. So we're not talking about long distance travel on a regular basis.
But, forgive me, part of the plan wasn't this is going to be a principally Glossop-based business. It was a wider geographical area. It was
Glossop and surrounding towns.
Yes.
Yeah.
So the point in the paragraph of the decision, second paragraph, is focused at the surrounding towns rather than Glossop itself.
It is on the basis that
I've never been to. I don't think I've ever been to Glossop, so it's not an enormous town. We could probably anyway. Travelling around Glossop is not something which is significant. The key point here was that travelling to the other towns.
Yes.
I had a marvellous case about Glossop.
Did you?
Not too long ago. Yes.
Well, I'm from the area originally, so I ought to know, but unfortunately, I've never been.
So I mean, the point my lord is making really is that if you look fairly again at the paragraph you showed me, it's not just about this one journey. The one journey is given as an example of how there isn't enough information about the travel costs. Is that wrong?
It wouldn't be sufficient in my submission when the context of paragraph 21 and how it is applied. It's much less onerous and exacting.
Is what you say.
I'm sorry?
You say it's nitpicking.
It is. It is. And I think that what was used there was a term used in the grounds, I think that it was trivial. And what ground 3 tried to say, well, we're not saying trivial per se, but have the broader picture in mind.
Does I haven't looked at the business plan in detail, and I will, but does the plan talk about competition within Glossop itself?
Yes.
And we're only all giving evidence now, but
It's on page 206 and 207.
Anybody who walks through the high streets of England can't fail to notice that there's been an increase in barber shops.
Mm-hmm.
So would it be fair to say that there'd be quite a lot of competition within Glossop itself because of the number of barber shops? They're all set out in the plan. We'll give it a page number. I didn't write it down. But
marvellous picture.
But the distinctive, might it be said, the distinctive feature of this application was the travelling element. That instead of being tied to premises in Glossop, he was going to be itinerant. That was the plan.
It's really 206 and 207.
Okay.
My lord, yes.
So really, the cross-check of the Marple, of the Marple client was the only evidence on which the decision maker had to go on to assess the viability of the travel proposal.
Well, of course, the travel proposal didn't just include the surrounding towns. It was Glossop as well. I mean, three of the customers. If I could take you to the potential customers' letters, that may be of use. Page 287.
Yeah.
Sorry, it starts at 286. Thank you. Certainly, the customer at 286 seems to be impressed with the appellant as an individual, in addition to the mobility of his services. 287 is the Marple client, and again, he has met the appellant in person and had an exchange with him, works long hours, prefers to have his hair cut at a weekend, so its convenience, for sure, is in the minds of some of these individuals. Page 288, Mr. Sand, finding a good barber is hard, but price is also a consideration. And at 289, the circumstances of the COVID outbreak had an impact on Mr. Nash's considerations. That the appellant seemed very talented, that he got along well with his children. So that there's an awful lot more to this business proposal and this appellant than the travel aspect. And that's why I say that the business plan is a much more complex proposal, and that it deals with so many different issues that would be necessary under paragraph 21 and the guidance. But to borrow a phrase from my lord, this particular point about you haven't provided a bus timetable is a nitpicky point that would not defeat the entire application on any proper analysis, applying paragraph 21 correctly and applying the guidance correctly. I feel like I've strayed somewhat from the grounds, but I hope that assists my lords.
Well, what you say, let me try and see if I can summarise it. You say even if what the court has put to you about credibility is right, he put forward a perfectly proper business plan in compliance with paragraph 21, and I've just looked at it, and it takes into account things like travelling, and it says there are frequent bus services to adjoining towns, so it at least goes that far. And so he ticked all the boxes of the paragraph 21, which is itself in very broad terms.
Yes.
And you say what the original decision did was to pick out, effectively, a nitpicking objection about a particular journey, which was meaningless in the context of that global business plan. And although it's dressed up as something more generally objecting to viability, you say, well, it's not a real reason to object to the plan, and the only detail given is bus timetables and a journey to Glossop. And he said there are frequent buses, so that's not really fair and not a proper reason. And though the reason given is viability, not credibility, you have to have some reason for saying a business is not viable, and they haven't. And all the review decision does is to say it was a reasonable decision in the first place. So the review decision doesn't take it any further or offer any other better reasons. Is that right?
Indeed, my lord.
So you would say that gets you home?
Yes.
Right. Okay. Anything?
Nothing.
No. Thank you. Well, thank you very much. Thank you. Yes, Mr. Owen.
My lord, my lord, like my own friend, I'll endeavour to deal with the grounds in the order that they're pleaded. My lords, on the first ground, the credibility ground.
Miss Dakin didn't do very well with that, Mr. Owen. Let's see how you do.
I'll start off with the same intention, my lord, even if I also meet her fate. My lord, on the credibility ground, I'm anxious not to cover ground which has already been identified by the court, so and also in my skeleton argument. So, what
Don't assume anything about the court.
We need
Credibility. No, my colleagues and I don't think that we need to hear you on credibility, but we do need to hear you effectively what is ground for.
I will. I'm grateful. On credibility, could I just give your lordships one reference in Carrigal rather than addressing it fully, which is paragraph 125 of Mr. Justice Saine's decision in Carrigal, just to emphasise that in Carrigal itself there were 4 claims before Mr. Justice Saini, and in each of those 4 cases, the Secretary of State, as she accepted before the judge, had made adverse findings as to genuineness on the facts of that case. And the relevance of that, of course, is that, as Mr. Justice Saini observed, when the Secretary of State makes those kinds of adverse findings, there are often consequences for future applications. So if somebody is found to have been dishonest in an application, then of course future applications can be prejudiced by that. So that
have the rules changed? Is there anything to stop him making an application today with bus timetables?
My lord, it's a good question. I'm afraid I don't know off the top of my head.
I think Ms. Dakin's going to say it has.
I'm grateful to Ms. Dakin.
Because of Brexit, this avenue is closed. He can't reapply.
I'm grateful to know that. But in any event, whether he can make exactly the same identical application may have been material to him. But the simple point is that Mr. Justice Saini's judgment and his approach to procedural fairness links back to the prejudicial impact of the finding of dishonesty by the Secretary of State on potentially any future application for immigration status in the UK. So that's the simple point on that. My lords, on ground 2, in relation to the SGK, again, unless there's anything specific I can address your lordships on, you have my skeleton argument on that point. And the simple point that's made there is that the Secretary of State can summarise my submission on it in this way. In the original decision, the absence of the SGK is, of course, noted. And your lordships might think that in the decision, the original decision, it's either clumsily put or the Secretary of State has missed the point which is raised in the administrative review by the appellant, to the effect that, well, if this is self-employed activity or an internship, which is what it appears to be, then it's not going to turn up on the SGK, and so it's not relevant. That, in my respectful submission, is dealt with in any event by the administrative review, and if I could briefly turn up the administrative review on this point, which is really the analysis at the bottom of page 307, which your lordships have already been through. I respectfully agree with my Lord Master of Rolls' characterisation of this analysis, which is in essence to say that we don't identify a viable business here, and the point which is made at the bottom of page 307, albeit I think I can say fairly rather clumsily, is that additional evidence of experience as a barber might potentially have strengthened the application, and that's why
That's
the
not what it
absence
says.
of
Mr. Owen, that's just simply not what it says.
my Lord, yes. So
What more, as a matter of fact, what more could this applicant have given?
my Lord, I'm grateful. I'm just looking at the bottom of page 307 and that paragraph that begins whilst it's acknowledged.
So am I.
Yes, I'm grateful. It would be considered that you would have
Would
been
have
able to provide
further evidence to demonstrate the
other than
credibility
two
of what?
reference letters you've submitted. Yes. So,
Other than the 2 reference letters? Well,
Yes.
well what? He's
Well-
given them all his experience.
yes.
It's not suggested, you've not identified anything else that he could have given.
No.
Do you identify anything now?
My Lord, no, I don't.
Well, in
and-
that case, on what basis can it properly be said that, as a result, it's not considered the original caseworker was unreasonable in their assessment? Because their assessment depended on the absence of an SGK, and as I understand our little exchange just now, you accept there wasn't anything else that could be given.
Well, Please, my Lord, in relation to experience, yes. But what I say the Administrative Review is saying there is that it's really a simple point, which is that the reason goes back to the reason why the original decision was made, which is, that is to say, we don't think you provided enough to show us that you've got a viable business. And so what...
it's no part of your case that he hasn't got a viable business because of absence of experience.
No, I respectfully agree with that, my Lord. No, I agree with that. Absolutely.
So we are on to travel.
We're on to travel, my Lord, yes. And so I'll come to travel if I may.
So you say further evidence in the third line of the last paragraph of 307 is not confined to further evidence of work history.
No, my Lord.
But further evidence broadly to demonstrate viability.
Precisely. What the Administrative Review is saying there is, in essence, going back to the original decision, we don't think you've shown us something that's going to get off the ground. And this may be speculation on part of the decision maker, and it may not make any difference to your Lordship's decision in any event, but I think it's probably right to say that had he had additional experience that was evidenced by an SGK, that might have assisted his application in general terms. Whether or not that would have then led to a positive decision is a moot point in any event.
That won't do. Sorry, Mr. Irving. Because the whole point about the SGK is it only deals with employment, and it was used by the original decision maker
Yes.
As if it were something that was relevant to a person who'd only ever been self-employed.
Well, I think in fairness to the original decision, my Lord, I'll respond to the point, although I say it may be that it becomes OTOs, but in the original decision at page 291, okay, can I make this? I accept. Look, I think it's my Lord the Marshal Rolls' observation that both decisions could certainly have been more elegantly drafted, to put it mildly.
I didn't mean to be rude about them.
I'm sure not, my Lord, and I respectfully agree with your Lordship's observation as well in terms of the amount of resource, in terms of time that is possible to put into these application or decision making. However, no SGK has been provided, therefore any work history claimed cannot be verified. It's accepted if that was intended, or if that referred to the time that was spent in February to July 2018 and July to December 2018, then bearing in mind the nature of that activity, that would be an incorrect reference. Yeah. But the simple point is that, as your Lordship has observed, the Secretary of State doesn't say you're not a qualified or competent barber. What the Secretary of State says is you don't have a business that's viable and going to get off the ground. So that's why I say that this may be a point which is...
Well, it's irrelevant. It's actually true, the sentence in question,
yes,
but irrelevant. And we can move on.
Yes, thank you.
But the question is that once you accept that there's no part of your case that he's not got a viable business apart from travel, right?
Yes.
And you haven't given any other reason, then you have to persuade us that your objection to his travel plans was a sustainable one.
Thank you, my Lord. And I'll endeavour to do so now.
Yes.
And it goes back to the business plan. And if your Lordship would be kind enough to turn to page 219, which is a page that's already been turned up.
299.
219, my Lord.
219.
And this is the projected figures for the first year of trading. And your Lordships will have picked up that there are later references, pages 221 and 223, which are broadly consistent with the figures that we see at page 219. The travel expenses element of this travelling barber business plan are the third largest expense on this balance sheet. £1,700. The only two which exceed
balance sheet.
I'm so sorry, my Lord. The profit and loss statement is how it's described on that same page. So it is the third largest expense, only after the salary of £9,600 and software and equipment of £1,950.
Yeah.
But there is no sign of where that figure comes from.
Well, I thought there was something that said something about buses. Where did I see that?
Local bus service is fast, frequent and connects the towns reaching into Manchester suburbs, on page 206.
Medieval.
Thank you. Market analysis, that's right. The local bus service is fast, frequent and connects the towns reaching into Manchester suburbs. I mean, I don't know what the buses cost in that area, but buses in my area are not very expensive.
No, my lord, of course there can be variation from place to place, but bearing in mind that this is the third largest expense on the projected profit loss account, and bearing in mind that the unique feature, as your lordships have already observed, of this business plan is that it is a travelling business, it is, in my respectful submission, perfectly open to the Secretary of State.
Well, should we look at the criticism that was actually made?
Yes.
The criticism that is made is the business plan states travel between each client using public transport. No information regarding public transport has been provided. Not quite true, because we've just looked at the passage that does give information about it being frequent and available.
With a footnote reference to a website for a bus
Yes.
services website.
Website, and then it says costings of daily, weekly, monthly tickets or timetables that show effective travel can be made within Glossop, etc., which are the areas which will be covered.
Yes.
Now, I mean, there's two possible criticisms there. Not enough info, but they've given the website. I'm not quite sure how you're supposed to show every bus service to every customer you haven't got yet. And then the second criticism is the time it's going to take during COVID to get to Glossop from Marple.
Vice versa, my lord, but yes, indeed.
I mean, is that fair?
My lord, in my respectful submission, it's certainly fair.
Well, I've just put in that website address, which I had not done before.
Yeah.
And I'm looking at a list of all the buses with a £2 single bus fare. Buxton, New Mills Town Service, Padfield, Hadfield, Station Road, Parkside School. There are 2, 4, 6, 8, 10, 12, about 30 buses.
Marple there?
My lord,
What, just as a matter of interest, what more is a person meant to do?
in my respectful submission, my lord, the answer to that is, to some degree, we are doing what, I may say what Lord Justice, or Mr. Justice Saini urged that we should not do, which is to go behind the decision which the Secretary of State's made.
Well, go back to the criteria.
Yes.
What mandates or indicates even that this level of detail has to be given?
Well, my lord, the answer to that is that where you are proposing to travel around by public transport, particularly during a pandemic, where there's limitations on that, and that is your major expense, in my respectful submission, it's certainly open to the Secretary of State to say that your business plan, which is the analysis which the Secretary of State is engaged in here, your business plan is simply not.
I would feel much happier about that if you were able to direct us to anything either in paragraph 21
Yes.
or in the guidance or anything which indicates that that level of detail is required.
It cannot be given, can it?
Well, Lord, I'll complete the submission if I may. My Lord, Lord Justice Stuart-Smith has asked for the guidance. Page 384.
384.
384 is internal page 53. Asks for or demands that any analysis of the application is accompanied that the applicant needs to satisfy the Secretary of State as to the income and outgoings, and sufficient to satisfy his needs. Page 388.
Sorry, I can't see those words.
I'm so sorry, my lord, I was paraphrasing, but the page 384 is about personal income. Realistically maintain and accommodate themselves.
Where are you?
At page 384 at the top.
Second paragraph.
Yes, second, the one that starts this page tells you.
Oh, yeah.
And then sufficient levels of profit. So has to show, in my respectful submission, clearly from that, have to show that there is sufficient profit going to be generated by the business, and if you're doing that, then you have to be able to justify the outgoings of the business.
But do you accept that the information provided included, by reference to the footnote, the website, which I referred to at the bottom, footnote 4 on page 206?
Yes, ma'am.
So that's part of the information provided.
Well, as part of the information provided as part of the business plan, what I say is that what the Secretary of State is objecting to in the challenge decision is the degree to which the business plan demonstrates that there is a viable business here with reference to the third expense that's listed in the proposed profit and loss, and bearing in mind the guidance that's required. Page.
Well,
forgive me,
I'm
yes.
sorry, I'm interrupting you.
No,
But
do
page
well.
309,
Yeah.
the objection is you did not provide any further information regarding the public transport you would be using to travel between clients, such as costings of tickets, timetables, etc. Well, that's all on this link.
Well, Lord, your Lordship has the advantage of me because I don't have the link before me. But if that is the link,
Do you want? I mean, this is not a frivolous offer. Do you want to see it?
No, thank you, my Lord. I don't. I can make the submission in the event, I think. If it is a general link to bus services in the area, that will not be, and the costings of those, that in my submission is not
But it says
sufficient.
£2 single bus fare for a start.
Yes, my Lord, indeed. Can I, if I may, I'll stick to just finish the submission on the guidance, if I
Yes.
may, which is page 384, which is a reference that I think has been, forgive me, I'm so sorry, page 388.
You said 388.
I'm very grateful.
I think that was the one
to
you were
my
trying
Lord.
to come to.
Yes, indeed.
Yes.
So this again makes clear, and of course this guidance is not intended to be prescriptive in the sense of setting out in detail exactly what documents are required. Indeed, it would probably be unlawful were it to do so or purport to do so, bearing in mind the nature of the rules here. But amongst other things, in essence, what the bullet points that are set out at 388 require is evidence sufficient to demonstrate a viable business plan.
Well,
And the applicant...
he's provided the second, third, fourth, fifth and sixth bullets.
Well, my Lord, he's provided a business plan, yes, and business accounts
Yes.
projected forward. Because of course they're not... it says if appropriate at the third bullet, so that will be for existing businesses rather than for future
Funding
businesses.
evidence. Yes.
And funding evidence, indeed, my Lord, yes.
Bank
But the
statements.
question then for the Secretary of State is whether or not those documents that he has provided demonstrate a viable business. What the appellant knew he must do was demonstrate that there was a viable business, including, in my respectful submission, demonstrating that the travel element was viable in two ways, and I'll come on to the second, if I may. The first being the costs which he has included in his business plan, but without any basis or justification for why he has come to that figure rather than to a different one. And the second is the viability in terms of conducting his business, which is where the time taken to get to Marple comes in, and potentially to other places. So the costs point is clearly relevant. It's referred to at the original decision. And the Marple travel time point is also relevant because...
Can I ask you this?
Yes,
Let's assume that the reviewer had looked at the website and investigated the bus fares in the neighbourhood and found out that you can travel from his home to Glossop on a bus in an hour and a quarter every day, and then you can hopefully arrange your diary so that your customers on Monday are in Glossop and your customers on Tuesday are in another adjoining town. So you go on one journey a day, which makes business sense. You are going to be paying £4 a day to get there, £2 there and £2 back. And that adds up to less than £1,700. So some days you may take 4 bus fares because you decide to do 2 locations in a day. Why does that not make perfect sense, and why does it have to be spelt out when nobody could possibly know precisely what they were going to be doing in such a business after COVID?
Well, my lord, the answer to that is that that isn't the appellant's case as it's set out in his business plan. His case is, to paraphrase, that he will travel between Glossop and the surrounding towns as far away as the suburbs of Manchester.
Sorry, I've got his place wrong. It's Glossop.
He is resident in Glossop, and there's one client identified in Marple. So his business plan is, I'm going to travel around Derbyshire as far as and into the suburbs.
So where does it say that he's going to do that?
Well, it's the reference that my Lord Professor Stuart-Smith raised to the frequent bus services going as far as Manchester.
But he also says that the basis of the, I think it's probably on the page before, that he's going to go to nearby, searching for barbers within a 10-mile radius, shows 4 barbers in Gloucester and more in neighbouring towns. No, that's not what I'm looking for. There is a reference. Yes, on that same page, on 2006, the town is close to lots of towns and villages on the main route into Manchester.
Yes.
This gives Mr. Ozmen more scope to expand his service location and cluster clients in different areas to reduce travelling time.
Indeed, my Lord, yes. And that's where I get that's why I say that it's not part of the appellant's case as it was put before the Secretary of State that he is going to cluster his clients, or he would even be in a position to do so.
But he's not. Sorry,
he's not going to cluster his clients. He's not going to attend Marple, for example, and cut 5 heads of hair rather than 1.
All tradesmen travelling around.
Well,
I mean, I'm going to give evidence. My gutters cleared this week, and the day it was done was Friday, because that's the day the gutter clearer was doing something else near my house, and that's how it works. They don't say, I mean, it's,
my Lord, yes, but of course not all tradesmen have viable businesses.
no.
Well, and looking at his breakdown, he's got a cash flow forecast which shows that he's going to be spending in the first month first 2 months £120 a month, then 130, and then 150, and then 170 as the business grows on travel. So if you assume 22 working days a month, £120
£5.50. £5.45, I think you'll find.
An average of £6 a day.
It's £5.45 if you do 22 days.
Okay.
But I'm grateful, Lord. Could I briefly move on, because there's the linked point about viability and time?
Yes.
Could Mr. Owen, before you do, I know it's, please forgive us, and particularly me, for interrupting you, because I know it's difficult. But I just want to go back to the point I made, if I may, the point which I picked up on, which was what's said in the original decision.
Yes.
And the original decision says, no information, I'm going to emphasise further words, forgive me again for doing so, but you'll appreciate why. No information regarding public transport has been provided, i.e. costings of daily, weekly, monthly tickets or timetables to show that effective travel can be made within Glossop and close by towns and villages, which are the areas that will be covered as stated in the business plan. Now, we must be careful. We can't assume that what my Lord or Duchess Stuart-Smith has discovered this morning was in place in 2021.
Indeed.
But there's no doubt, is there, that the business plan referred to a website which we can assume would have given some details along the lines that my lord has discovered.
Yes.
So isn't it wrong to say no information has been given to show that effective travel can be made within Glossop and surrounding towns?
Well, my lord, I think what it's not saying is that there aren't buses, and that those buses are unaffordable. It's effective in the context of assessing the business. And that, first of all, I accept that the link that my Lord Justice Stuart-Smith has followed, I think we can assume, would have led to some sort of timetable and costings website. But what the objection is not so much to the existence of that information on the internet, which no doubt is there, but how that has been brought in to constructing a viable business plan. And if I may, this is where the Marple to Glossop travel time becomes material as well, because the Marple to Glossop travel time is 1 hour and 15 minutes each way, according to the check that was done at the time of this decision, thereby 2.5 hours in total in terms of travel time. The only potential client who is based in Marple is Callum Morris at page 287. You see, your lordships will see the letter from him. And Mr. Morris, you'll see from the 3rd paragraph of that letter, is expecting to pay £26 for his haircut.
And I'll also be recommending his services to my colleagues who are in similar situations in Glossop, presumably.
In Marple potentially,
in Marple,
but we don't know.
It's Glossop to Marple.
Yeah,
Yes,
no, I know, I'm sorry.
I'm grateful. But we don't know. We simply don't know.
We're bouncing around, but you were giving us references
Yes, Lord.
in the guidance or whatever, which
Well,
you
yes.
say support the level of detail that you are advocating. So you gave us 2 pages, 384 and 389. Are there any others?
My Lord, I don't believe that there are any others that deal with the point in more detail than that. What I say, my Lord, is that the whole of the guidance taken in the RAND, and indeed the paragraph 21 itself, asks the question, show us that you've got a viable business.
You might want to digest. Thank you. You might want to digest the fact that the bus timetable for Glossop to Marple,
Yes.
or the other way around, from Glossop to Marple, shows that if you catch the 6:40, you get in at about 7:05. It's about a 25-minute bus journey.
My Lord, yes. And that's a point that was made in the Administrative Review as well, that the bus timetable was altered in 2021 because of COVID.
No, some of the buses were withdrawn.
I'm grateful, Lord. Yes, forgive me. The buses were withdrawn. At the time the decision was made, the assessment or the information that was sourced or looked at by the decision maker showed an 1 hour and 15-minute
But
journey
the decision
time.
maker didn't go to the bus timetables. He went to Google Maps, which, as you know, is quite different.
My Lord, it is different. However, it is a commonly accessed travel planning website, if I would put it that way, which includes information about public transport options.
It is.
So, yes.
Sorry.
Grateful.
It is odd, isn't it? The more one thinks about it, the decision maker referred to a survey on a different website from the one which he'd been referred to.
My Lord, you may think so, Lord. I'm not sure I can say much more on the point, which is that Google Maps is a commonly accessed resource. People use it.
But surely,
It
even
is.
if he was right, I mean, even if it did take 1 hour and a quarter,
Yes.
it doesn't destroy the business plan.
Well, my Lord, it's not about destroying the business plan. It's about whether or not there is a viable business plan that has been put before the Secretary of State.
Well, I mean, can I ask you this specifically? You said right at the beginning of your submissions that the no part of your case that he hasn't got a viable business apart from travel. So you need to show us that he does not have a viable business. It was a reasonable thing to say. You don't need to show us you're right. You just need to show as a rational reason
Yes.
to say that it wasn't a good reason. And I must say, speaking only for myself, it looks to me as if when you actually dig down into what was being said, it's a little bit unfair, isn't it?
Well, Lord, I don't accept that. I think there's 2 elements to this. The one is about the Secretary of State questioning whether or not the business plan, which has figures for travel, as it must do, because this is a travelling barber's business reliant upon the public transport network, whether or not the figures that have been provided have been properly worked out and justified with reference to the intended conduct of this business. Now, if the business plan said, well, I don't know whether I'm going to be trying to travel daily almost to Manchester, I don't know whether I'm going to have to travel 6 or 8 times in a day by bus to go to different villages around Glossop, but I'm going to adopt a reasonable approach and take an average of what I think I might be doing, well, that might be one thing, but he doesn't say that. He simply plucks a figure apparently out of thin air.
Is that not a bit nitpicking for a business of this kind? I mean,
yes.
the chap cannot know where all his customers are going to be, and if you take at face value the letters, he's persuaded at least 4 people that he's a skilled man,
yes,
who's energetic and wants to ply his trade.
My lord, yes, although those 4 are not going to keep him in work for 22 days out of the month. But I unless they want very frequent barbering services, certainly more frequent than mine. My lord,
It won't surprise you, Mr. Owen, to know that we were discussing our barber requirements before we came into court.
There's only so much we're prepared to divulge.
well, thank you. I think it's fair to say that I could certainly use his services at the moment. But in terms of that element, my lord, I respectfully disagree that it is nitpicking because it is the third.
You say
expense.
it's not nitpicking.
I think it's not
you,
nitpicking.
you say it's a perfectly reasonable
Yes.
criticism, effectively, of the business plan, and you adopt the point I made right at the beginning to the appellant, which is that this is a matter for the Secretary of State
I do, yes.
on
And
viability.
indeed. And the question of whether he would end up spending, or how he gets to the figure of £1,700 a year is up in the air.
Anybody knows?
No one knows. And the second point, my lord, is the linked one of can you run a viable business turning over in excess of £25,000 a year if you're spending potentially 2.5 hours on a bus, or even if it's only an hour on a bus, to go and cut a single head for £26.
I think 25 minutes, according to my lord.
25 minutes to and fro, plus waiting time, of course, my lord. But if you're spending an hour to an hour and a half, even if you discount the COVID element, to cut a single head, well, is that a viable business plan? Query.
Well, it may be part of a viable business plan. It may not be profitable at the outset, and he may decide that Marple is a dead end eventually.
He may do, my lord, yes.
He may do. But that's the point, I think, of taking us to whichever paragraph of Mr. Justice Saini's argument. It's not a straitjacket, it's a projection. And some bits may do better, may do less well than he hopes.
Yes, well, I think that my friend took you to a Kinji, which is not Mr. Justice
Not
Saini's
quite
judgment,
Kinji,
it's not
yep,
the Tribunal.
quite right.
And I accept that, of course, it's not a straitjacket. Nevertheless, thinking about the travel, it boils down to the travel part of the proposed business. It may be that the travel itself, the length of time travelling, renders the business unviable, or it may be that the expenditure is unjustified.
Can I just ask you about one other thing?
Yes, ma'am.
What happens if he gets leave on this basis and the business fails?
My lord, certainly my recollection of the rules, I don't want to mislead the court, my recollection is that it's open to him to then remain and open a further business if he wishes to. I'll turn to my own friend.
Sorry, open to him to what?
But Lord, I may be able to assist. If this application were granted, he'd be given 12 months leave to remain.
Yeah.
At which stage he could apply for further.
You then have to reapply.
He would have to demonstrate that his business.
And if it's
worked.
a complete turkey, then
Then it'd be refused.
I'm sorry.
That's not a
That's
legal
awful.
expression.
That's awful. I mean, it's completely unintentional. I'm very sorry. It had no connotations whatsoever.
He was thinking of the ambiguity of the word credibility.
Thank you.
Thought that he would give an analogy.
Yes.
But, my lord, the periods of leave are 12 months. If at that stage it's successful, he'd be given 3 years. And another argument went on, but eventually indefinite leave to remain. But at each stage would have to show that the business
A viable business.
was working.
Okay.
Yeah.
Thank you.
I'm very grateful, I'm afraid. Yes. My lord, I suspect you have my suspicions on this, which boils down to question of viability, a matter for the Secretary of State
Matter
to
for the Secretary.
evaluate, and there was certainly sufficient there in relation to travel to give rise to the rejection.
Thank you very much, Mr. Owen.
Thank you.
Yes, in reply, please, Miss Dakin.
Greater degree of analysis than in Dragon's Den. If I could just
Television programme.
draw your attention to a couple of references in the guidance and to link back to the business plan. Page 373 of the bundle. Under the heading...
Sorry, 373.
Yes. Under the heading, assessing the applicant meets the requirements.
I take it, Ms. Dakin, you adopt some of the points that the court was making to Mr. Owen,
Oh, indeed.
insofar as they were favourable to your case.
Indeed. 100%.
You don't need to repeat them.
No.
Yeah.
Part way down, you'll see a business plan should set out, and then a number of bullet points.
Yeah.
So the respondent's guidance accepts that this is a summary of the business proposal, an outline of marketing and sales strategy, timetable for establishment, financial forecast for the business over 12 months of trading. That's against the background in the preceding paragraphs of the broad nature of the 1973 rules.
And you showed us a kinship.
Yes. And so even on the respondent's guidance, a business plan is summary in nature. It's an outline. So the level of detail that my learned friend contends is not only necessary, but that the applicant would have known was necessary, is simply not present on the face of the rules or the guidance. There's no other part of the guidance that even mentions travel, save for perhaps the need to show a driving licence if someone proposed to be a driver as a business, for example. It may be a mandatory requirement of the business itself. But there is nothing in the guidance that would alert an applicant that not only would they need to provide an outline of how the business is going to work, but they would have to provide the level of detail about how they're going to travel beyond what the applicant has done in this case.
But I think what Mr. Irwin is saying is, in this case, the 1,700 figure for travel expenses has nothing to support it, except on the footnote, the assertion about travel and the footnote that we've alighted on.
It's not an unreasonable figure. I mean, if someone was providing an outline and they've provided the source of their conclusion, I think, as my Lord Master of the Rolls observed, what more could he be expected to provide? Is he supposed to provide every timetable and projection?
In theory, he could have said, I've taken £1,700 a year on the basis that I will do 3 days a week in Glossop, incurring no costs at all, 1 day in Marple, which is going to cost me £10, and 1 day somewhere else, which I'm assuming will cost me no more than £10. And that, I mean, he could have done that. The question is whether that is either is necessary, is necessarily required of an applicant who gives the details of costings that we've this morning discovered.
Indeed, and the short answer is no, it's not required. In light of the rules, the guidance, and what he's actually provided, although the Secretary of State may have wanted more and clearly went off and did their own research about it, it wasn't necessary.
Well, there's no sign that they clicked on the link.
No, there isn't. And certainly in terms of projection, the applicant has given an indication as to how he proposes to organise his business. So at page 206, a passage that has already been referred to, and this is under market analysis. The applicant identifies that the town is close to lots of towns and villages, but that as he expands, he proposes to cluster clients in different areas to reduce travelling time. 206. And so, as the authorities recognise, a business will take time to get underway. The head note in Akinci at subparagraph 3 even recognises that a business may not even be profitable in the short term as a business gets underway. But is it viable on the basis of this plan? In my submission, the respondents' criticisms are unfounded and are not founded in what is reasonably expected of applicants on the basis of the rules and the guidance.
Glossop is on the main road between Sheffield and a main road between Sheffield and Manchester.
Manchester, yeah.
Marple is not.
It's not a place that I'm personally familiar
established
with.
that.
But
it is on a road from
Yes.
Sheffield to Manchester, but it's not
a main.
And what he says in at market analysis on 206 is the town Glossop is close to lots of towns, but is on the main route into Manchester.
Yeah. Yes.
So Marple is
an outlier.
Another
yeah,
town. Yeah.
on one view would be not typical of the sort of places he'd be focusing. Other,
I think
we're reading too much.
it would be difficult without analysis of a map.
That's the sort of analysis. Yeah.
Yeah. But the appellant has demonstrated he has in mind how things may progress and how he will organise his business. He's provided a reasonable figure during the first year, bearing in mind he would only be given a year to get this business underway before he'd then got to demonstrate how it has actually worked if he wanted to remain and continue in business. No doubt there will have been changes that he will be able to say, well, I've started, I realised that this was too far, that was too expensive, and now here's my core customer base.
So when he applies again, does he have to go through the same process, the same degree of detail, the same, it's all over again with the plan? Yeah. At that stage, he'll have more concrete information. Would have.
Exactly. It won't be projections, but it will be evidence of what I told you I was planning on doing has actually worked in this way. And it's really quite a short period of time to demonstrate that. And that's why it's important to bear in mind that these are projections and ideas. And what Akinci says about that is you've got to give applicants the flexibility to put those ideas into practice. But on the face of it, the applicant has done what is required of him to show that this is viable.
Is there any authority for the proposition that at the second stage, for the 3-year application, you are expected to show more detail? Or is it just obvious?
Not more detail. I mean, EK was a decision...
also, Mr. Justice Blake.
Yes. That's at page 54 of the authorities bundle. This was a case at the indefinite leave to remain application stage. And paragraph 28 of HC 510 applies at that stage. And as you'll see in the head notes at paragraph 2, it wasn't a precondition of the exercise of discretion that an applicant should demonstrate in each and every year that they've been given leave in this capacity, that they complied with the requirements of paragraph 21. So it really demonstrates the scope of these rules. They really are very broad, and the approach of the respondent in this case is out with the requirements.
And they no longer apply anymore, is that right?
They're preserved in the sense that anybody who's in the category
right, but for a new applicant, it's not relevant
No,
anymore.
they don't apply anymore.
Right.
Came to an end 31st of December 2020, sorry, for new applicants. Yes, there was no transitional period. Yep.
Okay. Anything else?
Those are my submissions.
Very good. Well, thank you both. It's been relatively quick. Thank you very much. We'll take time to consider our judgments and hand them down in the usual way. When we do, we only want typographical corrections, and you may only use the embargoed judgment for the purpose of agreeing an order and any consequential directions and costs, and otherwise it should remain confidential. Thank you very much.
All rise if able.